This is the third episode of a series of webinars that the Armenian Bar Association's Young Lawyers Committee is putting on new and emerging areas of law. Each webinar is geared towards providing an introductory and useful information for new attorneys who want to break into certain areas of law and start practicing in them, and experienced attorneys to get more information about areas they might want to transition their practice into. This is the third episode. As I mentioned, it'll focus on cybersecurity and data privacy. All the webinars are recorded and they're available on the Armenian Bar Association's YouTube channel, and there should be CLE information as well in the chat box. Just to lay out really quickly what the plan is for the webinars, we're going to start with a discussion about certain cybersecurity topics, and the panel, we have an incredible panel, is going to talk about cybersecurity topics. Then we'll probably move into some issues on data privacy. We'll have a section where we'll talk about the panel's various career paths to lead them into these areas of law that might be informational and helpful for the participants on this webinar who might be interested in pursuing these areas of law. And then hopefully we'll have some time for a little bit of questions, a little bit of Q&A at the end. So I'm going to start by introducing myself in the panel. My name is Ohanian. I'm an assistant general counsel at the National Security Agency. I've been there for several years, and before that I spent quite a bit of time in the private sector and private practice. We have an incredible panel. The panel, and I'll just introduce them and provide some brief bios for them. Raymond Aghaian is a partner at Kilpatrick, Townsend, and Stockton. He specializes in cybersecurity and privacy, as well as high-stakes civil and criminal litigation. He's also a former federal prosecutor working in cyber crimes and intellectual property crimes. Ghazarian is the general counsel of DreamHost. That's a website and domain and cloud company based in Los Angeles. He heads the legal M&A and international expansion for DreamHost and deals with data privacy and cybersecurity on a daily basis. We also have Ghoogassian, who is an attorney specializing in digital health and privacy. She's currently a senior privacy and commercial counsel at Doximity. She also teaches a health privacy course at USC Gould School of Law. And prior to Doximity, Chloe was counsel for Amgen's digital health and innovation team. And finally, we have Nareg Froundjian, who is an associate attorney in data privacy, cybersecurity, and technology at Deloitte Legal. As part of the Deloitte Legal Canada LLP's data privacy and cybersecurity practice group, Nareg advises leading Canadian institutions on data privacy, cybersecurity, and tech law matters. So this is a really great panel. There's a lot of knowledge about these topics, and I'm looking forward to kind of posing some questions and hopefully getting some great discussion on these topics. The first question in this cybersecurity area that I think is probably on a lot of people's minds, and it's a pretty timely, relevant topic, is the issue of ransomware. And for those who are new to the issue, or it's something that they're just starting to learn a lot more about, the basics of it are, and at a basic level, is that when a cyber actor who's attempting to commit a ransomware attack finds some kind of access vector to a computer system, whether it's a phishing email or some other type of tactic, and they get into the system, they'll use malicious code of some kind to encrypt and lock the data, denying access to the data owner, and eventually typically issuing a ransom demand to the data owner in order to get it unlocked and to get the encryption key. There's been a lot of high-profile ransomware attacks recently that have been in the news, including the Colonial Pipeline attack that disrupted gas supply to the East Coast and elsewhere. So I want to turn it over to maybe start with Chris and ask Chris, do you have any thoughts, and then the whole panel, but do you have any thoughts on why there's been an increase in these incidents and in these attacks, and what are you how is this affecting your practice or your kind of counsel for your clients?
Sure, I think there are multiple reasons why we're seeing a crazy, I guess, resurgence of these things happening these days. I mean, obviously with COVID, one of the biggest factors has been that people are not working in offices anymore. A lot of them are working from home, or they had a remote style of handling business when they didn't really have that beforehand. So you had companies who were, extremely knowledgeable and careful about cybersecurity, and then all of a sudden all of their workforce went home. But then a lot of these people had to continue working on the same computers, on their personal computers, on their cell phones. So a lot of the technology that we were using for work is now becoming hybrid, and there are a lot of different ways that people can gain access to those areas. So I think one of the bigger areas in a multitude of things is the fact that so many people started going remote, and so many of the devices that we use that were basically more secured pre-COVID are now subject to so many different security holes because of the fact that everyone's at home, everyone's taking their devices around, doing work things on their home phones, on their cell phones. So there's a big gap there, and obviously people are taking advantage of that. From our perspective, I mean, we doubled down on security, or we hired more people in our cybersecurity teams. We stepped up working with outside counsel. I mean, Ray on the panel is our go-to counsel when it comes to privacy and cyber issues. So being careful and making sure everything's covered there is really what matters. We've been remote in the past, so it was easier for us, but I'm sure with companies that have been, you know, not remote, it's been a huge struggle.
Ray, what do you think about, do you have any thoughts on
Sure.
what you're counseling your clients on?
Sure. So I think, you know, there's a convergence of two really basic points. Number one is, I think data information itself has value, and there's a black market for information, number one. And you've seen somewhat of a prevalence of some of these attacks because it is a very lucrative way to obtain information and to sell information, much more so than you can doing other forms of criminal activity, first and foremost. And number two, we hear more about it now because there are more obligations, duties, responsibilities, legal requirements for people or entities that are compromised to report these types of attacks. In fact, there's now discussion that the FBI, the DOJ, are pushing Congress to pass legislation to require companies to report ransomware type attacks. And we're hearing more and more of it as it becomes more acceptable and people understand, you know, what a ransomware attack is and what a data breach is. It's becoming less of a public issue for companies to disclose this. And in fact, they want to get in front of the issue and disclose this as they have legal obligations to do so, obviously, but they want to get in front of this and disclose this before somebody else. Some report comes out saying this entity was compromised, and the entity hasn't had the opportunity to really disclose that information, which kind of leaves it a black eye. And so I think, you know, the black market that's been created for information, particularly when you have state-sponsored actors. I mean, we could go back, it was, you know, now we're talking maybe 8-9 years ago when the reports first came out about a particular military unit in the Chinese military called Unit 61398, which their sole task was to infiltrate and compromise Fortune 500 companies in the United States to obtain information. And we've seen that grow more and more, and it's kind of come down to not just limited to state actors with very sophisticated ways of compromising, infiltrating companies' information, but it's filtered down to maybe less sophisticated actors that are able to do so as well. So we're seeing not only more of it, but we're hearing more people, more companies reporting it. So it's just a convergence of the two together.
That's interesting. So do you have any thoughts on, as you mentioned, kind of legal disclosure obligations, that's something that's being talked about a lot. Do you have any other thoughts on the legal remedies out there or legal avenues to improving the posture for companies or just for kind of public interest in general in terms of, you know, preventing these attacks? Because there's been talk about that. There's been talk about maybe banning cryptocurrency payments or banning ransomware payments, period. I mean, do you have any thoughts on that?
Yeah, I mean, so as of now, I mean, let's just take California as an example. Back in what was it, in 2016, where our former vice president was the attorney general of the state, issued a rule that essentially said that you would have to have, quote unquote, reasonable security under California law. You have to comply with the law, and the law required for you to have, quote unquote, reasonable security. Reasonable security was essentially defined in certain ways in terms of what that was. It's still kind of out there in terms of what constitutes reasonable security for, you know, the type of company you are, the size of the company, and things of that sort. But, you know, speaking of cryptocurrency, what we see more when there is a attack and a company's servers have been compromised, more and more we see that the compromise may not be so much to obtain the data, but to use the processing power of the computer servers of the entity to mine cryptocurrency. And so a lot of times when we conduct an investigation and we're looking into some of these issues, we'll find out that there really was not much of a compromise of any data. Was there a reasonable belief that data may have been compromised? They may have had access to it, but may have not accessed it. And sometimes the trick to this is we cannot tell whether the data itself was in fact accessed or not. It's as if saying, you know, I know that somebody broke into your home, they went into your office, but we are not sure if they opened that file cabinet that obtains those files that we're concerned about, and whether there's been in fact, breach of that data and access to that data. And a lot of times you see hackers are essentially, if we call them hackers, when they're compromising the system, they're getting into to use the processing power to essentially mine cryptocurrency and not access data as well. So it kind of complicates things a little bit.
That's interesting. Nareg, do you have any thoughts on kind of some of these same issues of, you know, are there legal remedies? Is there some differences from the Canadian side of things? You know, do you have a different experience or similar experience with some of these issues?
Oh, for sure. I mean, I agree with everything that's been said so far. One thing I want to add is that the ransomware industry is getting more and more sophisticated. So it used to be that it was, you know, one person or a group of individuals that would compromise the assets, that would develop the malware, that would deploy the malware, that would, you know, execute the extortion activity. Right now, you're having specialized groups that are doing each one of these as the industry matures. Why is it maturing? There's a lot of money in there. So what we have is ransomware as a service, and we're seeing a lot of that being deployed where it's not the actual threat actor, you know, the group behind it, Revel, DarkSide, NetWalker, whatever it is. They're just running a ransomware as a service. They're offering a crypto locker. They're saying, here, take this. We'll give you 85% of, you know, whatever money you can get out of it. We'll keep 15%, and we deal with a network of affiliates. Like, this is sophisticated business level organized crime that exists. And the main objective is usually money. Afterwards, we have ransomware that's targeting national critical infrastructure. I think that's something important to point out in light of the colonial attacks. But in light of, you know, 2 weeks ago, Aramco got hit again. That's the Saudi Arabian gas company. They got hit again. That's the third time they're getting hit. So whether or not these are state actors, it's not clear. Maybe it's, you know, the state kind of condoning it or turning a blind eye to it. It's really tough to tell. And even in the files we're in, we don't necessarily venture off into attribution. To Ray's point about, you know, the laws that exist, we think, you know, they're helpful. It encourages companies to have reasonable safeguards, but only to the extent that they're processing personal information, health information, financial information. They're in the energy sector, perhaps. But other than that, you know, as long as the laws don't necessarily come with hefty fines, that's not really what's motivating people. And companies really need to think of, you know, what's the impact on my reputation? What happens if my operations stop all of a sudden, right? Colonial, the issue wasn't that, you know, customers' data was breached. They weren't going to report under the California Consumer Protection Act, right? Like, that wasn't necessarily going to happen. But their operations just slowed down to a crawl, and they were losing multiple millions of dollars a day to the point where you don't have a choice but to pay the ransom. It's really tough, and I don't think there's a silver bullet. I mean, there's talks about, hey, let's stop paying ransomware. And if everybody stops, okay, cool. But that's really going to require everybody to band together and come to an agreement to not pay it. And if you make it illegal, all you do is to push it underground. So people are not going to disclose. They're going to pay the ransoms anyway, and they're going to keep quiet. There's no easy way out of this. And I don't, if I had the answer, I think I'd be way too, I wouldn't be able to be here. I'd be solicited everywhere, right? Like there's no magical answer. One thing that I do remember, and Ray really put his finger on it, is not knowing what's being accessed. I think his description was great. Companies, one thing they should be doing is investing in logging capabilities. And that's what we find whenever, like my job is that actually I get the phone call. They say, okay, we've been breached. What do we do? Right. And I lead the team of investigators that go in and we respond to the breach. And one of the things that is oftentimes deficient is logging capabilities. So to take Ray's analogy, if there's tripwires on every room in the house and we know whether or not somebody went into the room, then it's really easy to say, well, they just went into the kitchen and that's all I need to care about. Nobody was in your office. Oftentimes companies don't have that, and that really complicates companies' response to a breach. So those are just a couple of thoughts bouncing off from what we have. I wish we have an answer. Maybe somebody around the table does have an answer. I'd be really curious to hear.
Yeah, does anyone else have thoughts about legal, whether the laws, I mean, as Nareg said, whether the law is realistically going to be either at the federal level or state level or what have you, is realistically going to provide a positive value here in terms of trying to correct the problem, or whether there's just going to have to be other incentives in terms of financial or otherwise for companies.
I mean, I think at the end of the day, the company has to take a top-down approach. You see a lot of companies now with various C-level folks that are just responsible for this, and they have to take a top-down approach and take this seriously, because it's really not a question of if you're going to get compromised. It's a question of when that happens. And we've been talking about this for years and years. It was a lot more difficult, talking about this 10 years ago than it is now, before the Target breach and all the larger breaches had happened back then. It was a more difficult conversation to have, and now it's a little easier. But at the same time, it's got to be a top-down approach where companies are taking this very seriously. And if you do understand that it's not a question of if, but when, then there are a lot of things you could do not only just from a intrusion protection system, but an intrusion detection system where you are able to log and identify what's happened, where and when, and take measures to minimize. If you look at, for instance, the various studies that are done in relation to the cost of a data breach, the primary issue is the dollars per file, right? And if you're able to reduce the number of files that are compromised within each breach, and you could do that, take various steps to do that, then your cost is less, the exposure is less. So there are various steps you could take beforehand in taking this top-down approach and carefully monitoring what your vendors are doing and what kind of access your vendors have, not just what your employees are doing and what you're doing. But if you're able to do that, then it's not a silver bullet, as it's been said, but there are various ways to tremendously minimize your exposure and the damage.
Ray, quick question. You mentioned C-suite executives, and maybe perhaps broader question to Chris, Chloe. Would we start triggering director and officer liability? Should laws start, saying that if you're not managing cyber risk at the board level, you're liable? A bit like in the Yahoo decision that came out, and there was, a shareholder class action, targeting the directors. That was a $27 million settlement. And that was the first, usually they say, okay, in, business judgment rule, you guys figure it out. You guys know what's best for the company. And right now, are we seeing a switch with Yahoo? Do you think that's coming?
Go ahead, guys. I think that in the C-suite level, there's certainly, you see more folks that are apprehensive and concerned. There have been a number of situations where folks have been looked at in terms of their responsibilities, their roles in what they were doing. But the business judgment rule, as you mentioned, is key. At the end of the day, our job as counsel to an entity is to provide the client whether it's the CISO or the, whoever or C-level executive we're talking about, is to provide them with the best information, give them the options, and for them to make the decision, and so that they could then avail themselves of the business judgment rule so that they don't face these type of issues. And I think that as counsel, if we are doing our job, folks like Chloe and Chris could avail themselves of that rule, and they can go back to their client and essentially tell them, here are the options, here's what the recommendation is from me and from outside counsel. And the client can then make that decision. And so, yes, but you do see, I think the short answer to your question is, I've actually seen much more of an apprehension and a concern amongst the C-level folks in relation to that issue.
I think that brings up a good point just to mention in terms of insurance too. Like when we've been renewing our insurance policies, we've noticed that premiums have been going up in two categories. It's director and manager liability and cyber. So a lot of those CISOs and other C-suite level people are definitely noticing what's happening. And to Ray's point, insurance is one side where they're doubling down and making sure that they have higher limits and more coverage. And obviously you pay a pretty penny more, but the cost benefit analysis there is definitely, it's there.
On my end, Doximity recently went public and we had an IPO a couple weeks ago. And so our C-suite is very much holding themselves accountable and wanting to be as diligent as possible with respect to privacy and cybersecurity. And so with public-facing companies, there's this additional burden to keep investors and the public happy. And so that also goes along with carrying insurance, being transparent to consumers, and also whoever is funneling money into your organization.
That's a helpful segue too, I think, because we want to make sure we segue into some of these privacy topics that I know that you have a lot of expertise in. What for you are some of the key considerations you're preparing your business clients about in terms of the some of the most prevalent privacy laws, whether it's California or Virginia, Colorado? What are the big things you're tackling?
Yeah, so there's a lot of new state privacy laws that are following along California's footsteps with CCPA. In California, CPRA will be enacted soon. Virginia's VDPA, Colorado's CPA. So they're all starting to be enforced in 2023. But the good news is that if your business is already compliant with CCPA, you're well on your way to crossing off a couple more boxes with respect to these other states. But first, you should determine if your business is in scope. So consider your size, like how many consumers you have, how many consumers are in each state, what revenue you're generating, so both the total revenue and how much revenue you generate from PI or personal information sales. And then based off of that, consider the additional requirements from the new laws. So with the CPRA change added to CPA, there's a new requirement for sharing, not just selling data. So this includes both non-monetary blanket sharing of data. There's new rights for sensitive PI. So there's a bunch of new categories that need to be carved out that are separate from just the general PI. And there's also correction rights. So consumers now have the right to correct any data that you have on them. In Colorado, there's a special opt-in for processing sensitive PI. So not only like in other states or in California right now, rather, consumers have a right to opt out of us or businesses using PI, but Colorado has a special opt-in. So that's going to be very burdensome for businesses doing business in Colorado. And then in Virginia, this isn't necessarily solidified yet. It hasn't really been understood amongst us lawyers, but there's a data risk assessment requirement. We're trying to figure out as a business what that means, if the data map is sufficient or not, but we'll figure that out as it's solidified. But my biggest thing is having a data map. So a lot of businesses already have this, but it's kind of been an uphill battle for me as the first privacy attorney at Doximity of, hey, like we need to know where all our data is. Just having a our engineering team or CTO having it in their head isn't enough. So with the data map, you determine what categories of PI are collected, the source, whether shared with third parties, how it's protected, etc. And then as a business, you should also know how you provide consumers with their access, deletion, and correction rights, and be transparent in the privacy policy. So with the new sensitive PI category and sharing rights in California, and also the new state privacy laws, you should, as a business, update your privacy policy. Couple more points. So with ad tech considerations, a lot of businesses are affected by these new privacy laws. So if you have service provider agreements with various vendors, check to see if PI is shared beyond your contract. So you might have in your contract now that, hey, you're not allowed to sell data beyond this contract or beyond this purpose of the service provider agreement, but they might share PI for cross-context behavioral advertising, which is tracking activity across web pages. And then if you determine that you as a business share PI beyond your four walls, you need to have a do not share button on your homepage, at least to comply with the CPRA, and have a method for making sure that you're complying with those consumer requests. And then lastly, there's a lot of changes to privacy laws, but so Apple's privacy update with iOS 14.5, so this is a big thing among a lot of companies. So it now requires apps or companies who have apps to provide consumers with the option to opt out of tracking across app activity. So first determine if your business does this. So if you have only a website and you don't track activity across your mobile app, you don't have to worry about this. But if you do, then you have to make sure that you have that turn on feature in the iOS function. And this is probably the worst news for Facebook because their entire business model is to track activity across apps. But all in all, as a consumer, for us, as consumers of businesses and websites and apps, these changes create more transparency and provide us with more control over how businesses use our data. As lawyers and business people, it's kind of a pain. I have opinions as to whether these regulations actually protect consumer privacy or not, but I think we'll probably see that in the years to come.
What's quickly worth mentioning about the Apple thing, by the way, the iOS request for do not track is actually the responsibility is on the app developer to honor that question. So it's just a really interesting point to make because I found that fascinating. Everyone said, amazing, Apple's doing such a great job for the user, but that's actually a request that gets relayed to the app developer, asking them to honor it. So it's not actually, stopping the data transfer. It's merely telling the developer that you cannot use it, which to me is really funny because if you have a developer who has other motives, they're just going to ignore that. But it's just an interesting point to make.
Well, absolutely, and it's a question for the panel and for Chloe in the panel, which was popping into my head when I was listening. Was do you picking up on that, Chris, and some points Chloe was making? Do you think automating, or is a lot of the work that needs to be done in this privacy space automating, whether it's requests for access to records or the way certain elements of compliance with these privacy laws should operate, or compliance with what you just described? Because that sounds like that's almost like a manual thing to do, to say, hey, to this app developer, will you, are you complying with this? Maybe an honor system kind of thing is what that almost sounds like, or at least a little more of a manual aspect to it. Do you think that companies would be in the best place possible, turning more to automation or doing certain things with their websites in different ways? I just want to kind of throw that back to the panel.
So for our business, we've had less than a dozen CCPA requests come in. So the way we see it is like, we'll do it if we get an email about it or we get a request, but it hasn't gotten to the point where we have to automate this just yet.
Yeah, for us, it's been, well, since GDPR, it's been quite an interesting exercise in terms of processing requests. And, you know, I think that the interesting thing is there are a lot of companies out there, I'm sure most of you have experienced this, they automate the request for the end user. So it's a third party where you can go sign up and they will literally shoot emails out to every service provider that you check off that you use. So we as DreamHost, we get emails from, there's an Israeli company that has probably sent us thousands of these at this point since GDPR, that says like, you know, this person is requesting that you delete all of their data, but they're also requesting that you continue providing them services. And you're like, I don't think they really know how this works. So, you know, if you have a company that obviously sells data or you're in the realm of big data, like that's a different story. But in our situation, we don't sell data. We don't gather data for the purpose of selling or trading it off to people. So my point being, the automation part of it can be different for different companies, because for us, it's not a one size fits all solution. We have to tell the customer every time, hey, if you want us to wipe your data, that's fine, but you can't wipe the fact that you own a domain name on the internet. And that rubs a lot of people the wrong way because they get offended. They're like, oh, that's, you know, ridiculous. Like, erase the fact that I own this domain. And you're like, well, that's publicly available knowledge for everyone in the world. Like, you've registered a domain name. That's not going to go away. You can remove your information from it, but the registration stays unless you want us to delete that and we can't give you your money back. But to bring it all the way back, automation, I think, will be a key role, because obviously, like, you know, Chloe said they've received a dozen requests or so. That's fantastic. But at some point when it starts ramping up, she doesn't want to be sitting there the entire time answering these manually or processing them. You want to have some solution. It really does go back to the data mapping that she talked about too, and understanding what you really do as a company, because most companies, you know, to bring up like marketing, for example, your marketing team in most companies, you know, they're aggressive. They, I think, are known to do a lot of different things that legal doesn't always have a handle on. And so you have to ask marketing, like, what was this contract you guys signed without telling us a couple of months ago? And why is this data leaving our servers and going over there to Egypt? But I digress. You know, it's something to always keep an eye on. And I think the more this happens, I mean, it's a huge area that you need to pay attention to. I don't think having, you know, one in-house attorney is enough anymore for data privacy and cyber. It's really going to be a behemoth of a topic.
Curious, because we spoke about GDPR quickly, and I've seen the data protection authorities in Europe be extremely active, issue guidance, help businesses. And I can speak a bit about the Canadian side, but we have 3 panelists from the US. And I know US, it's not regulated federally, but it's state-based. There's talks of federal legislation. Are the privacy commissioners or data protection authorities active? Do they help businesses in reaching these objectives and putting, you know, the right security safeguards in place and conducting a data privacy impact assessment, a bit like Chloe mentioned, right? Where, you know, you do your data mapping, what's the risk to individuals, et cetera. Like, do you guys get any kind of guidance like that?
In my experience, no, it's been a lot of outside counsel trying to conjecture and figure out what these laws mean, especially when CCPA was first enacted. It was like a cluster of everyone just putting their heads together and trying to figure out what these definitions mean. And it was very poorly drafted legislation. And so CPRA hoped to solidify that and kind of make it more clear. The CPRA will have an enforcement agency that may resolve some of this, that may, you know, help businesses understand some of these changes. But in my experience, no, regulators are not helpful.
Yeah, there's in fact, not only are they not helpful, I think there's just conflicting laws in various states. And so where you might be compliant in one state, you may not be in another. And so you're often finding yourself in a position where you're trying to, see how you're going to comply with all the rules and what's the lowest common denominator, so to speak, and identifying what that is. And sometimes whether it's California law or Massachusetts, and you're going to take the lowest common denominator being the most stringent and apply that, because there are different standards. And you'll often see, and you could go search on the internet and you'll find dozens and dozens of charts breaking down, here are the 50 state laws on this privacy issue, and each state has a different, a tweak to it that can make a significant difference. And so, you don't really see much of a guidance in that sense. And a lot of this legislation is the product of compromise. And so there's a lot of ambiguity. And the CCPA, as Chloe mentioned, was had tremendous ambiguity, it still does. And so, so it's not only, not helpful, but often it seems to just counterintuitive in a lot of ways.
One question for the panel that I think gets talked about a lot, and it's continuing to recur. And in fact, I'll confess I haven't read up on the specifics of it, but I noticed a headline recently somewhere about federal privacy legislation potentially being reintroduced again. And I didn't dig too deeply into it, but what is the, does the panel have any opinions about whether it's that particular bill, if anyone's, very familiar with it, or others that they've seen or things that they think might come? How likely do you think that is? And if it doesn't involve preemption, do we even think it's going to help or just be another layer of kind of complicating factors, or are the states just kind of driving the train at this point, and it's unlikely? I mean, does the panel have any thoughts on that? I think it'd be interesting to know.
I think the states are definitely driving the train now, but it's very confusing for us lawyers to navigate this, to make sure that we address each and every single state law. And so there is a desire for a federal uniform state privacy law. And I think GDPR had it figured out with several of the countries, or all the countries in the EU. But yeah, I think preemption will be interesting too, because for example, now HIPAA preempts the state privacy laws, but with CPRA, there's this new category of sensitive personal information, and that includes health information, but in some ways it's more stringent than HIPAA. So it's just all very confusing. And yeah, I'm looking forward to federal law. I haven't heard of anything being drafted, but it'll be great.
Yeah, I mean, it's kind of like reading the tea leaves on this. It's, there's been numerous efforts in trying to put legislation together, federal legislation together, but it hasn't worked. Again, product of compromise, but there's been no compromise, and it's just sometimes scary to think what that product at the end would look like, given the difficulty and the number of efforts that have been made to try to put such legislation together. What does that legislation actually look like at the end? Who knows? But yeah, that would be the ideal situation. Right now, what you have the states driving that, and then you have for entities that are governed by various agencies, the agencies themselves. If you're a public entity, then you look at what the SEC is doing and so on. And so you have the various agencies that are issuing their own regulations, guidance, and you have to comply with that. You have to make sure you comply with state regulations in addition to that. So it's just a quagmire of various rules and regulations that you have to comply with. And if there was a uniform standard to be applied, that would make things a lot easier. And I think it would actually help in terms of driving security and increasing the level of security, because folks would have a better understanding of it. Companies would have a better understanding and would be willing to enforce that. They know exactly what's required. And, it's up to the legislation to then set that the heightened level of what that level is going to be in terms of what that security requirement is going to be. So, maybe there are nuances in terms of if you handle X type of information, then there's, a different type of standard, but all of that can be fleshed out in the legislation itself.
Anyone else have thoughts on potential federal legislation? Are you writing it over there, Chris? Are you writing the federal legislation?
Yeah, I've been working
now.
Yeah, nights and weekends, that's my job, my side gig. No, I think I think Chloe and Ray summed it up nicely. I mean, government hasn't been able to find consensus in any of this, and so you've seen this massive push from states, and as Ray pointed out, different sectors basically addressing privacy issues themselves. So the approach for us is so fragmented, and you're just lost in a sea of many different laws to follow. And do you follow the most stringent one? Like, do you go with the one that's most active in terms of regulation? It's such a mess. And while GDPR did do a decent job in consolidating all of that, I think it will take some time to see something similar here. It's just it's so crazy, but thankfully I don't have to think much about that. We can leave our wonderful elected officials to take care of that bit.
Any reassurance to my co-panelists, it's not that much better in Canada. We have provincial legislation, we have industry legislation, and we have federal legislation as well, but it doesn't apply if the provinces have their own legislation. So it's just as fragmented. One thing I did hear is that, okay, the GDPR is great. And based on that, we've started advising businesses to use privacy as a business enabler and not as a compliance exercise. And we see many large businesses with international operations being very responsive to that model. And one of them, we can take Apple for an example, right? Like, they're putting forward privacy and saying, we value your privacy. They had ads on TV saying, we are the company that will protect your privacy. So going above and beyond and using that as a differentiator, I'd be curious to hear maybe from Chris, from Chloe, how do you feel about that within your business? Is that something that you put forward? Is this something that you work with marketing teams to say, we're a privacy first company?
100%, especially since we're a healthcare technology company. We primarily care about patient privacy, and granted, we don't have a lot of PHI in our day-to-day business, but we want to have doctors be able to trust us to use the tool. And because we've been kind of like a privacy by design company, we've dominated the market share of doctors who use our tool versus others. But I've found, at least being in-house counsel over the past couple of years, that being an essential part of the business and being part of the team as a partner versus just the last step in the process or the naysayer has completely changed the way businesses have looked at lawyers. We are now crucial in the engineering process and trying to figure out ad tech and just helping think through some of these issues, because the business also doesn't want to redo everything when they find out at the last stage, like, hey, there's something wrong here legally. So I think privacy by design is the way to go in the future of how companies will be looking at privacy.
Yeah, absolutely. I mean, for DreamHost, so we've been around, I think, 21 or 22 years at this point, and we've always had privacy at the core of our product offering, right? And I think that wasn't ever done to be like a marketing tool or something. It's just, 4 dudes out of college started a hosting company, and all they cared about was protecting people's data. And so we've actually been relatively, I would say, modest about marketing that and announcing that, but we started doing it right around, I think, pre-GDPR, because we realized that data was becoming such a big deal. And it's funny because obviously people care about this thing. Even with the Apple situation we talked about, like Nareg pointed out, they're blasting everyone with these ads about Apple and privacy. And in the world of Apple versus, let's say, Google, of course, they're a little more protective of your data, but I think people fail to realize that data is still the core asset for a lot of what they do. But yeah, privacy should be a huge part of the company push. And as Chloe mentioned, the in-house counsel cannot be on the back burner when it comes to this. And quite the contrary, I think the lawyer has to be the leader when it comes to privacy. Even if you have a cybersec team or a security team internally, it's just so much more valuable to have a legally trained professional leading the way. And whether you're doing it yourself or working with outside counsel, which I highly recommend you do, like Ray, you have to have a game plan. You have to implement those, and you have to be on top of privacy. It can no longer be an afterthought.
And I would just add that, I think privacy itself is a product, an offering in terms of what a company provides to its clients, consumers. And you will see a lot of companies will stake their interests in that and are willing to go to battle and fight to preserve the privacy rights of their clients, of their consumers, to protect that name, to protect that product. And then I think, one of the companies that's done that best is in fact DreamHost, and they've taken a very aggressive stance towards protecting the privacy of their members and their consumers. And I think you see a lot of companies doing that, and there really isn't often, these, litigation that's involved in related to these issues can be protracted, and there really isn't a monetary sort of benefit to this other than just protecting the privacy rights of their customers and protecting their name. But you see that more and more because companies realize what an important piece of their business offering that is for their consumers to appreciate and feel comfortable with their data and how it's protected.
That's really helpful. I think we've got some transitions, I think, to some of the kind of career path, but it's also one of the questions we got in terms of the question section about how law students and others can get into a career that focuses on cybersecurity and data privacy. So I can just speak quickly for myself, but then I'd love to turn it over to the panel there's so many different types of experience here. I started as a complex commercial litigator. I spent the first 5.5 years of my career doing that. There were a lot of technology patent infringement cases I handled, which sensitized me to some of these issues, but I was mostly in the litigation space until the opportunity came up to join the agency, and I've really enjoyed working on both in the litigation context and operations context, working these issues. It was a little bit kind of seeing a job opening and applying, to be honest. It was something I was very interested in, but I didn't necessarily know anybody out here before I kind of made the move. So that was my personal path. It's been something I've been really happy with and really passionate about, but I kind of just followed the opportunities a little bit there. But yeah, I want to turn it off and I'll just kind of go down the line. Nareg, kind of how did you get into this field?
It's an excellent question. Started off with a knack for technology, been a geek, worked at, anywhere from like Best Buy, Apple, cell phone companies throughout, my education, academic setting. Went to grad school. Afterwards, decided to start a master's in tech law. Got involved in how technology influences the justice system. Worked 3 years in academia and research. I knew I liked it. I knew I wanted to push there. I ended up articling in a rather large law firm, right? I liked it a lot. I got the tech files at the end of my articles. There wasn't a match. They said, hey, do you want to do M&A? I said, no, I want to do tech. So I started my own law firm, and then eventually there was an opportunity to start this at a Big Four at Deloitte. And I said, okay, well, they're talking about the Big Four disrupting the field of law. I think that's the next place to be. And that's how I really got into a niche focus in cybersecurity and data privacy. And what I do basically on the day-to-day is I do breach response, and it's great. It's a big adrenaline rush, and for as long as I can do it, I'm happy to continue doing this.
That's great. Chloe, how about your career path?
So I also started off doing litigation. I worked in healthcare business litigation at a law firm. And then I had an opportunity to go to UCLA Health and work on the compliance and privacy side. And so I was kind of like a regulatory person there. I ran privacy investigations and contract negotiations. But like Nareg, I got really interested in the technology aspect of it. And I got an opportunity to work at Amgen in-house for their digital health and innovation team. And so I was kind of like their general tech counsel within this smaller group at Amgen. And I, at the same time, was asked to develop and teach a health privacy course at USC. So I've always been a privacy nerd, and to the extent that I could exercise that brain while I was at Amgen, it was really exciting for me. And then I've been at Doximity for the past few months as their privacy and commercial counsel. But my advice to law students is don't think of the traditional like have to land a big law firm job, have to be like go from A to Z. And there's like certain steps of doing it. There's opportunities that will present themselves to you. Just talk to people, network, try to figure out how they got to where they got to, and it's going to be exciting for you.
Ray, how about your career path?
So it's been interesting. I spent my last year and year after in undergrad working on a internet dial-up startup company, which went nowhere. And then hope nobody from UC Hastings is listening to this, but I spent my entire third year of law school working on a different startup where we were putting supercomputers together to provide rendering services for animation companies. And we raised funding, and that went nowhere. And I ended up becoming a real lawyer. But thereafter, I was at law firms, and I was always interested in the technology aspect of things, particularly when involved theft of trade secret issues and IP-related issues. And ultimately, when I was with the Justice Department as an assistant U.S. attorney, I was in the cyber and IP crimes unit, and that's where I really got to kind of hone in on learning, about cyber attacks and things like that, and theft of trade secrets, and saw that the theft of trade secret is stealing a trade secret is much more lucrative and easier doing it through cyber crimes than any other means. So, and once I left the government and went back to private practice, this is now almost 10 years ago, things were different. I mean, the practice has evolved, and companies didn't really look at large law firms back then as someone you would hire to deal with cybersecurity. It was much more of an afterthought when a breach had happened. But there's interesting ways to deal with those type of issues. And for me, from a cybersecurity privacy practice standpoint, in private practice, it was much more about counseling clients in protecting, in preemptive measures, in making sure that they had preventive security, whether it was helping them conduct pen tests, or helping them deal with vendors that would come in and do various tests, and trying to protect that information under the attorney-client privilege to make sure that it wasn't discoverable. Because a lot of times you would see, an entity wanting to do some kind of bring an IT tech company to do some kind of a test, that the IT tech company would tell the client that there are 50 things wrong with their system, or their system is deficient. The company at the end would only want to do 5 or 10 things out of the 50. And then you had an issue of the 40 remaining recommendations by their own vendor just being left out there. And if litigation happened, it was a problem. So, we would go in there and essentially hire the vendors, and they would assist us in providing the company with legal advice, which would be attorney-client privilege communications and work product. And we would try to protect that information. So there was various other ways to try to get into this field. And sometimes you have to be more creative in terms of the service and product that you're offering to your client. But that's kind of been my path. So it's been very fulfilling and very rewarding, and I've enjoyed it.
That's great. And then Chris, how about your path?
So my path started in law school because my first job in law was here at DreamHost. I started interning at the company when I was a 2L, and it was fairly new to me. I mean, I think like most people here, I'm kind of a low-key geek when it comes to tech, and so that was one of my interests. And so this position came up, I applied for it, I got the job in-house. And I interned there for the summer of my 2L year. And it started off as a pretty typical in-house job, a lot of like contracts and redlining and just helping the GC back then with every assignment or whatever there was. But I slowly realized that I want more than that. I don't want to just sit there and redline contracts all summer. So took it upon myself to do more things and try to typical stuff like impress the CEO and give him like a memo. Like I think I wrote a memo on ADA issues back then, and he kind of looked at me like, who the hell are you? But you know, I wanted to give him something that I did. I'm like, look, I did this on my own time for you guys as a company. But anyway, like that's how it all started. And then I got the job offer, you know, 12 weeks later, and I've been there since. And to bring it back to how you can get onto this path, it's very much a non-traditional path, right? Like you can't just go and buy like Gorman's book on copyright law and read the book and finish it and know what you're doing. Like privacy law and cybersec, like it's an ever-changing area of law. And so you need to be out there reading newspapers, reading online stories. You need to be networking with people. I networked with a ton of people. I mean, Ray was one of them, but I used him as a mentor. Like we would meet and I would ask him questions about this area that I had no idea about. So I think a curious mind is definitely one that will help you on this path, because it's not like it falls in your lap and you just come across a privacy law job. I think it really takes a lot of common knowledge and day-to-day happenings that you need to be aware of. So data breaches, you need to be aware of them. Like you need to understand all the things that are happening in today's world, so that when you walk into a room for a privacy job or a cybersec job, you're not just educated by the book. You're very much aware of everything happening today. And that's what I would recommend, is keep reading current events, network as much as you can. And if you're not into tech and geeky stuff, start being in them a little bit, start getting into them.
That's really great. I think everybody probably appreciates your different perspectives on all this. And I think we have a couple of minutes. We can try to grab a few questions. And I think, Chloe, I might just start with you for this question, because it seems like it might be in your space. It's the question regarding working with global tech and biotech startups and with security on their mind. What's some general advice you would give to maybe founders of a startup relating to privacy and kind of cybersecurity, where to kind of start getting, maybe up to speed in this area?
Yeah, so if you're at a startup, if like, let's say you're building a company from the ground up, I think just like we mentioned before, having privacy at the core of your business, creating a data map from the outset, understanding where your data sources are coming from, knowing who to talk to in the business in order to find this information out, and just being very transparent with your consumers about what you do with privacy. I think having a very well written and easily read privacy policy is very important. And I think that's the best thing you can do to generate trust among your consumers. But with respect to biotech and other health related startups and tech companies, there's the added layer of HIPAA and understanding what your requirements are from a health privacy perspective. And yeah, I think it takes time to really understand what that looks like and what that will be for your company. But as long as you have a data map, and you could tell that I'm a big proponent of it, as long as you have a data map and know what you're doing with personal information, I think you're on a good track.
There's another question, and anyone feel free to jump in these, but I'll just send this to Nareg because you have a different perspective with the Canadian perspective. There's a question that says, are any, what's your perspective on whether certain countries have a better privacy model than others, whether that's GDPR, maybe Canada, although you seem to maybe not based on what you described earlier, but do you have any thoughts on that?
I mean, doing it right is tough. There's no right answer. And if we ask, like, I used to hang out a lot in academic circles. GDPR is being criticized for being 10 years too late, right? And it starts by, okay, what's right? And we need to get to the same conclusion as to what right is. That being said, there are certain things that, should be constants everywhere. I think we all agree that the consent model is broken across the board. So any new legislation that's coming in that's relying solely on the consent model, I mean, the critics are all there. Quebec, my home province, tried to pass new legislation or is trying to pass it. Canada federally is trying to overhaul its legislation and is really relying on consent. And what the foremost thinkers are saying is that nobody reads the privacy policy. Nobody understands what you're trying to get me to consent to. So how could a model work based on consent? And then on the other side, there are certain things for which we don't necessarily want to go and ask for consent. When we need information in order to, enact public good policies, like things that are good for the public overall, well, should we really be asking for consent, or can we create exceptions in the law? So maybe, think about going beyond that. And one thought is something that a professor left me with years ago and said, you know what, maybe we're going to end up in a world in 10, 15 years, where it's going to be really weird if you don't have your data leaked. If, you're not public, like there's something wrong with you in a sense, right? As opposed to right now where your information is out there. So maybe we're going to move to a world where it's a lot more open, but let's see. Countries that are doing nothing are doing it wrong. That being said.
Are there any other perspectives on either of those two questions in terms of, are there advice you would have for startups and companies in the privacy space, or, perspectives on the best privacy law that you think's out there right now from your perspective?
I don't think there's one correct answer. I mean, to Nareg's point, I think, every country, every jurisdiction is trying something different. I don't think any one of them is doing something right at this point, because, some of them are overly burdensome. Some of them have so many loopholes that, companies out there are finding ways around them and still selling your data because, let's face it, nowadays you feel like you think about something and it shows up as an ad on your phone like 5 minutes later. But yeah, I think it's an ever-changing world, right? And I think one of the things that have been mentioned is monetizing your data, right? I think a lot of people have talked about this new world order where we get to a point where your data is worth something and there's value to it. So Google says, like, instead of giving you email for free, you pay $12 a year, but I won't read any of your emails or your content. I think people in general underestimate how much of their data is used. So it's going to be a very difficult transition going from what we're talking about to the idealistic world of privacy, because I don't think even us on this panel or in the audience understand how much of our data is being used on a daily basis on so many levels. So trying to educate the greater public and letting them protect themselves is a difficult game.
Well, I know we've gone a little over, so I'll just ask the panel if they have any parting thoughts kind of on kind of pressing privacy issues or things they want to add.
I would just add that it's, stay alert and be aware of new legislation in various jurisdictions as it's continuing to come up on a daily basis, weekly basis. And it does really change the landscape that you're playing in. And so you have to stay abreast of what's going on. And ultimately, from both the privacy and security perspective, you have to get in front of it. You cannot be in a reactive position. And if you're with a company, you have to address that internally in the C-suite level and have a top-down approach, as we've talked about. One thing I will add, I did see a question, and I think it's worth just very briefly responding to that. There was a question that I see is listed about, what if you're on the offensive aspect of a cyber attack? And that is a really interesting topic because at least in the United States, hacking back is unlawful. The Computer Fraud and Abuse Act, which is under Title 18, Section 1030 of the United States Code, says any unauthorized access or access without authorization or access exceeding authorization is an unlawful act, and that's a crime. I mean, there's a civil remedy for that as well, which we often use in filing lawsuits. But hacking back and taking an offensive measure, whether you've been hacked or you're just doing this to test things, is under the law unlawful, and it constitutes a crime. So be very, very careful in doing that, whether you're setting up a honeycomb or whatever other measures that you're using that can be deemed to be offensive. And if you have access something without authorization, you yourself have engaged in unauthorized access and hacking. So be very careful. Just thought I had to mention that because I saw that question. So,
no, thanks, definitely. And Chloe, Nareg, any final thoughts before we close?
Just that technology will always outpace regulations, and so the more we innovate, regulations will always be about 10 years behind. So just keep an eye out, be abreast of changes in laws, and make sure that you and your business teams are agile enough to change as regulations do.
I'm going to leave our spectators with some personal advice that they can implement in their day-to-day lives. Keep in mind that there's no free meal, so watch out. Whatever emails you get, there's no more Nigerian princes, and phishing is very, very sophisticated, so watch out. I can get tricked, you can get tricked, be vigilant. Second thing is, make sure your passwords are robust, and I know it sounds silly. If you can't remember a 32-character password, use a password manager. Do it. And then finally, if out of all of these you need to implement one, is two-factor authentication, because I've been in so many breaches, so many fraud cases where it could have been avoided if they had simply enabled two-factor authentication. That applies in your personal life, and that applies within the business units that you're advising or working in. So that's my takeaway in cyber. And then just somewhat related to ransomware, because I think it's important, if one day you need to pay the ransom in Bitcoin, either own Bitcoin, ideally, at least understand Bitcoin.
Thanks, Nareg. That's definitely some helpful parting thoughts there. I want to thank the whole panel. It was an incredible amount of, I think, knowledge and just an incredible discussion. I think everyone benefited from it. And yep, I think this is a great discussion. Thanks to everybody. And it'll be recorded as well on the Armenian Bar Association YouTube channel. So thanks again, and I hope everyone has a great night.
Thank you all.
Thank you.
Thank you. It's been a pleasure.